Well, welcome back to the TuckerAllen Virtual Town Hall. I'm Scott Trout, and I'll be the moderator, as usual, for our town hall, where we have our panel of TuckerAllen attorneys. So we welcome back to our town hall, Teresa and Kevin. Welcome.
Hi, thanks, Scott.
Hi, Scott.
Hi there. So remember, we want to answer your questions live. So you can submit those via the Q&A section during our broadcast today, and we'll try to get those to our attorneys as we have some questions coming in already. We're going to be talking about something important, that is money, and what happens to the money when you pass away. It's the age-old question of where it goes, what's the process, what happens. We're going to cover some topics, specifically what you can do to be proactive and what happens with your money after you take those steps. So check us out at TuckerAllen.com or give us a call at 866-335-3375. You can also submit your questions if you don't want to ask them here. You can check us out on the web and submit questions via email. And we'll get those to those during either our Friday Facebook Live at TuckerAllen Live on Fridays at 1 o'clock Central Time. If you haven't checked that out, 15 minutes each Friday, 1 o'clock. We'll be seeing you and talking a little bit about a short topic on estate and elder law. So check us out as well across social media. Go to the website again, TuckerAllen.com. Plenty of resources. The most important thing in this pandemic is, for the most part, we can handle everything from the comfort of your home, your office, wherever you may be. Most of the time, you don't even have to come into the office. You can do consults via Zoom, just like this, via phone. And for the most part, we can prepare documents for you. So if that's something you feel uncomfortable with, we certainly can share that information with you. Schedule a consultation. Go to TuckerAllen.com. Keep in mind, again, this is educational, informational. There's just so much particular that would be discussed during a consultation for you that we can't establish an attorney-client relationship or give you legal advice in this virtual town hall. So get some paper out, get a pencil or a pen, take some notes, and we're going to be talking about that. Money and what happens to it today. And so again, we've got Teresa from Edwardsville and Kevin from the Independence Kansas City office. They'll be joining us to talk here shortly, but let's just take a quick break. And then in the second half, we'll be addressing your questions. So we'll be right back after this break.
I wasn't really avoiding it, but I'm pretty good at procrastinating. I needed a trust. When I found TuckerAllen, all our questions were answered, all of our fears allayed.
You want your wishes in place, so there's no guessing, no stress on the children.
Basically, they talk about what you need, what's important to you. It was more conversational, really very simple.
All right, welcome back. And, as we talk about, it's being very simple, very conversational, and that's what this is designed to be. Try to break it down. We do that on Fridays. We break the topics down from my perspective, not knowing necessarily what, the area of wills and trusts, and try to bring the questions that I know you have to our TuckerAllen attorneys. So let's start off the top, Teresa. We have talked, I know, a lot about TOD, POD, and beneficiary designations, obviously. Let's walk through that again for everyone, break it down. And I know we were talking off camera. I have an experience with it just this weekend with a friend, and I want to ask you questions about that. I know that probably will resonate with those that are watching and listening. So TOD, POD, beneficiary designation, how does that affect money? How does it, get money to where you want it to go? How can it be used?
Yeah, absolutely. So when people think about estate planning, they immediately think to jump to thinking about wills and trusts. But really, the first line of defense that you have when you think about passing down assets is beneficiary designations. And then TOD, transfer on death, POD, payable on death. Those are just different ways to describe beneficiary designations. And it really depends on whichever financial institution or whichever bank that you work with. They each have their own TOD forms or POD forms that they prepare for you. So essentially, because it's the first line of defense, if something happens before the will, the trust even kicks into place, your loved ones, their first place to look is on your assets if you have any direct beneficiaries listed, whether the assets are TOD or POD to someone. All they have to do is present the death certificate, and then it goes to that person. So it is kind of like that first line of defense, the smoothest way of transferring to.
So is there a limit to what types of property can be used? I know I talked a couple months ago. I was actually registering a new vehicle, and the person behind the desk said, "Oh, do you want a TOD?" I've had that asked, which is really interesting and actually encouraging to suggest people to not forget this planning that they can do, the simple steps. But are there limits as to what you can do? Does it have to have a title, or can it be a checking? What is the limit for someone who's watching right now when they're thinking about the things that they have where they may want to use a TOD or a POD? And what's the limits there?
I mean, there aren't really limits per se as to what assets can or cannot have TODs. It's more like any assets where you have a title to, for example, the cars, which is actually really encouraging to hear that the DMV was asking that, because cars is a very common thing for people to miss a TOD on. But like bank accounts, retirement accounts, life insurance, all of those have beneficiary designations, and even stocks like individual bonds, stocks, those things you can also set up beneficiaries. Even for businesses, you can set up beneficiaries too. So there isn't really a limit as to what you can set a beneficiary on. I think the only thing to kind of draw a distinction on is personal jewelry, collectibles, those tangible personal property things. There isn't really a legal mechanism to say this is the beneficiary on this thing, unless you like write up a memorandum that's like incorporated in your trust or in your will to pass those things down.
So what is the distinction between the TOD and the POD, right? And the transfer or payable, what is the difference?
There really isn't a difference. It just depends on who's using what lingo. I know a lot of times for cars, they say it's a TOD. I think it depends on the bank. It really depends on who you work with. But just know that POD and TOD, they mean the same thing.
Right.
And just as parallel for real estate, it's called a beneficiary deed here in Missouri. It's called a transfer on death instrument in Illinois. So the deed is a little bit different in that it's less universally called TOD or POD.
Right.
So.
Well, as we keep talking about this, remind everyone that you can submit your questions via the Q&A section here in Zoom. Right down the bottom, there's a little highlight of that icon. Click it, submit your questions. We'll get to those here in the second half of our presentation today. We have some questions we're going to go through just as a reminder. So staying with you, Teresa, we talked a little bit about this offline, and I thought it was of interest to those that would be joining us today. Personal experience, I had someone, a friend whose relative passed. And interestingly, they had a will, but they also had TOD. So, and they were all these checking accounts, financial accounts, stock accounts, a car, everything. The will said split between two people. But the assets themselves were all TOD to one of those individuals. So the question that came to me over the weekend, which I was like, oh, well, that's really interesting because I don't practice in this area, was what controls here? If someone's actually taking the steps, the smart steps to put TOD, what is going to control when you have these two different directives?
So unfortunately for that second person in the will, TOD takes precedence here. So that person, if everything has a TOD to that one person, then that one person gets everything. The second person just has to hope that that one person wants to share, because essentially a will is only there to cover you if anything has to go through probate. So whenever you have a will, I always tell my clients, I want you to think of that as a backup, because when you have a will, that means you're anticipating things to go through probate. Unless you have a pour-over will, when you have a trust, then that's just another safety net feature. But the TOD, the POD, those take precedence. And if something doesn't have a beneficiary, then it goes through probate. Then the will kicks up and says, hey, probate judge, this is what I want you to do with those assets. Right.
So the interesting thing with the TOD, and as you were speaking, I'm thinking, okay, there's someone here watching now. I know that maybe they have a will, but they haven't done any TOD designations. Can they do that now with existing accounts? Can they just call the financial institution and say, hey, I need to change the title to a transfer on death? Is that something they can do rather than at the instance that they open that account?
Yes, absolutely. And that's actually what we tell clients all the time, saying, hey, these assets, when they come in for consultations, I ask them generally their different asset portfolio. And I say, okay, which ones have beneficiaries, which don't? For the ones that don't, please go and set a beneficiary on it. If you create a trust, we'll get into this later, we suggest the trust be the beneficiary in a lot of cases. But absolutely, they can go and say, hey, I heard that I can set a beneficiary on here. Sometimes they can even do it if you have an online portal with a bank or something. You can try to update it that way. Sometimes you have to call and speak to somebody to set it up, but definitely.
And there was, interestingly, and I'm curious your thoughts, again, personal experience. We all learn from personal experiences or things that our friends and acquaintances go through. Maybe perhaps a word of caution, and curious what your thought is on stock, on a transfer or payable on death. One instance that I'm aware of where there were 3 siblings, and the intent of the mother was, I want each of them to have equal. And they were all, let's just say 100 shares, but 3 different stocks. At the time of death, one of the stocks had skyrocketed in value. And I mean skyrocketed comparatively. So there was huge disparity. Let's just say one stock's worth 100,000 and the other 2 are worth 10,000 each. But at the time they were at TOD, they were equal. I mean, that's a downside, right?
I mean, that is a downside. So that's why a lot of times if you have more things, we recommend a trust. It's to avoid things like that, to have a common beneficiary, the trust as a common basket to catch all things so that whatever falls in, it can divide things up equitably amongst your beneficiaries if that's your goal. Yes, the downside of having a beneficiary designation like TOD or POD is that essentially it's going to that one person. Or even if you set up 2 people, it might not cover everybody as equitably as you imagine it to be.
Yeah, I mean, that's where it comes in. We're working with your financial advisor when you're thinking about the TODs or the PODs is important, because if your intent is to try to do a good, nice, equal distribution, if that is the case, you want to sit down with them and say, okay, here I've got this, but this one pays massive dividends and this one looks like it's appreciating. And then you also, what we'd like to do, the team approach, you get your financial advisor or your financial planner, and you get your the trust and will attorney to kind of all work together, right? Where you can make, just as you suggested, hey, maybe the trust vehicle is a better way to do it. And then the financial planner helps the client and you to assist in that way, right?
Yeah, I think in that example, that would have been really helpful to kind of loop an attorney in and say, hey, stocks, they can grow variably and you have no idea what they're going to grow to be. Maybe it's not the best idea to say one type of stock per kid, like that one kid got really lucky. So if they had looped in an attorney at the beginning of the process, then maybe they could have had that discussion about having the trust and the benefits of that. So.
It's every action has a consequence. And that's the thing, as long as you understand what the consequences are. And that's the conversation. I think it's important. I was speaking with a financial advisor yesterday, and that's the point is, to get that equal input from across the board, I think is very important to understand their perspective, our perspective. And we were just talking about that team approach, which I think is critical to have. So
I think it's important for them to all get the options, like all the different options, pros and cons. And of course, in the end, it's for the client to decide what they want.
Right. Yeah. As long as they know, I mean, there's so many variables. And I think when you throw out these, the TOD and the POD, everyone's heard of it. And then you've got the DMV suggesting it. And, but sounds great. It's a great first step, but let's just kind of make sure you dig. Like anything, let's just be fully informed about it. It's like liken it to this. Hey, I've got a headache. I'm going to take an aspirin. Now, is 1 or 3 more appropriate? Depends how many milligrams it is, right? You just have to dig a little bit to understand what the appropriate action is. 1 may just touch it a little bit, 3 may knock it out. Same kind of concept here. It's asking questions and hoping to get more answers, and that's why we're doing this today. So, Kevin, let's talk about probate. Probate, we use that word a lot. I hear it thrown about. What happens? What is it? What makes it kick in? Kind of walk everyone through that.
Sure. So what probate is, it's that legal process of administering. So the person who has passed away, it's administering their estate. So it's a really important process in that this property, these assets that the person who's passed away, the decedent, their property is stuck in title to their name and they're no longer living. So this is the process of transferring that title back to a person who is living or persons, not just one person.
Yeah. So we talk about a will, we talk about a trust. I mean, it's always, these are like great little steps moving along the way. I think we even talked about it at Facebook Live or TuckerAllen Live last week about buckets. We like to use the word buckets because I think Teresa started us off with it. It's a great visual description. So let's talk about funding, trust funding. When you have a will and a trust, what you hear people say, and if there's a question, we're going to talk about it here in the second half about funding. What is trust funding and what is that process?
Sure. So trust funding, that is, like Teresa had said, you have this, the metaphor is a bucket, and then your assets would be things that you would want to put into this bucket. And whenever you're funding your trust, you are taking those assets and you're placing them into your bucket. So they're all held, like Teresa was just saying, in kind of like a common space that makes it much easier to divide assets and make payments, things like that. So, but the process of funding your trust, that's the process of kind of making, where Teresa was talking about earlier, having those POD or TOD designations, making those designations to your trust. Or the other way that it could be done is where you just put the asset, the ownership of the asset, to the name of the trust. So those are the two options to fund.
So if I do the will, I do the trust, that's what I've seen commercials. I hear about, hey, you got to do a will and a trust, but I don't fund it. Pretty much done for nothing, or you go to probate at that point? What happens?
So if you have a trust and you don't get it funded, there are things that are called pour over wills, and what they are, they're set up, they're in place for things, for assets that don't get funded into the trust. So it's, the pour over will is not something, if you have a trust, that you really want to have to utilize, but it's there, it's that catch-all. And what it does, it tells the probate judge, we want to take these assets that didn't make it into the trust, and then we want to pour them into that trust bucket, is what it's saying.
So the whole process, and we try to, I heard someone the other day, I was just in Pat, they say, yeah, we got our will done. Mm-hmm. And I said, well, did you do a trust? No, we got a will, we're covered. But the point is that it's a great step, because now breaking it down. Why do I do a will? I want to know where my stuff's going to go. I want to direct it. But the point is without the trust, if you just have the will, you may be going through the whole probate process, right?
Yes. So Teresa, oftentimes she likes to say that the will acts as an instruction sheet for the probate judge, and that's a great analogy. That's what a will is. So a will is not probate avoidant. It does not keep your family members or your loved ones out of probate court, whereas a trust that's fully funded, it will stay out of probate court. There's no probate for a fully funded trust, whereas a will, again, it's just an instruction sheet, so you're going to end up in probate.
Yeah, so it's partially a successful first step, because we all want to know and have some say in where our things go. And we want, maybe we have a very specific request, something that we want, I want this person to have a watch. But again, I'd want to avoid the costs associated, because there is, right? There's attorney's fees, your personal representative has to go to court. I mean, that's added stuff that comes out of your estate that otherwise would pass free of attorney's fees.
Yes. So whenever you go to a probate court in Missouri here, you're going to have a lawyer. It's just a time consuming process as well. This isn't a short process. So just like, if I could, just a quick overview of kind of what is involved in the probate process. So you have a thing, there will be a personal representative, and oftentimes you name them in your will. And that's the person that's going to go to court on, your behalf after you pass away and help administer your will. And so that person has to file an application with the probate court to act as your personal representative. Then after they've done that, then they have to send out like a notice to a paper. And the goal of that is just to alert potential beneficiaries as well as potential creditors. And then you have to wait around for a while to make sure that no creditors come forward. Then after that, the personal representatives, they need to provide an inventory and appraisal of all the property in the probate estate to the probate court. And then after that, then the probate court can close the matter, and the personal representative gets to distribute the property. And then finally, the personal representative has to file an accounting with the probate court again to say, okay, the wishes we were instructed, we've done those. Here's where I line out line by line that I've done these things. So it's a very time consuming process. And like you said, it can be expensive here.
Yeah.
It can cost anywhere from 5 to 20% of your entire estate.
And I mean, it sounds, it's an honor. Maybe I was, again, listening this weekend about how there was a dispute between brothers over who would be the executor or the personal representative. And they were angry that, one wasn't appointed, but I'm thinking it comes with a cost, and that cost being this, as you just listed out, all this stuff, being organized and being responsible and being, attentive to the things that you have to do in the reports and the notices. And it's just a lot of work, especially when you're grieving over someone that perhaps you were so close to.
Yeah, absolutely. It's you could liken it to a job. This is not something that you can knock out on a couple of Saturday afternoons. This is a time-consuming process. You're going to have to be in court. It's not an easy thing to do, especially like you were saying, whenever you're grieving for someone.
Yeah. And I do think, we talk about wills and you hear about wills, and I was just watching a TV commercial for this, a company that we all probably know of, and they think they just oversimplify it. They're like, in this time, in this uncertainty, you need a will. Well, it just seems, but the trust is the whole point, that it's probate avoidant, right? I mean, that's the next step that you should be taking for a number of reasons. That could be, we've talked about before with the CARES Act and tax issues, and maybe you have taxable estate issues that you have to be concerned about. The will just doesn't do it, does it?
No, for all those issues, the will is just not going to be quite enough. And then another kind of option that you're talking about for people that might want something more than a will would be anyone who has minor children. So whenever you have minor children, a trust is a much better option for them than just a will. Yeah.
And then, I don't want to, again, the whole process, avoid the will contests and the disputes and the arguments, and just let it all go and how you exactly want it, to make it easy for people when you do go. Have conversations. We were mentioning when you have these TODs and PODs and you have a will and a trust, and go to the people that you either have appointed or that will be beneficiaries, and just talk to them about it and say, hey, I've taken these steps. This is where it is, the go package. We've mentioned that if you don't know what it is, you need to find out more about it. Right. And so, that's just a really good step, right?
Yeah, absolutely. It's one of the first steps. Make sure you have that conversation. Just, if nothing else, it's nice to know that this is kind of lurking in your future if you are one of those people.
Yeah. And we've mentioned it, and I always like to plug it because it's such an amazing program. When we talked about funding a minute ago, and we talked about maybe TODs, and maybe you're acquiring assets, and you've already taken the steps, that legacy protection program that you guys offer, which gets you an opportunity to meet with you every year, to look at your documents, to make sure that they're up to date, to make sure that the designations that you've done are accurate, that are consistent, or you need to fund a piece of property, or you need to do a TOD, or you need, like the CARES Act, things that change in 2020 that's so important to be included in your trust. It's included in the legacy protection program, right?
Yep, that's all included. And then also, any of those minor changes that people have all the time. Maybe they have a child that whenever they set up their trust was, 15 years old, and they can't be a POA, they can't act as an agent for them. And now the child's 23 and they're out of college and they're doing well, they're great. They trust them to be their power of attorney. And, just for us to kind of make that switch, that's something else that would be included in that.
Yeah, or life-changing event, a divorce, and you didn't, change some documents that you need to do, which is so critically important. Not only your life insurance designation on your beneficiary, but your trusts, to make sure if that's, if you want to change, those are the moments where you should do it. And you shouldn't really have to pay these huge fees to an attorney to go do it. And that's the whole point of that annual legacy protection program. So if you want more information, you need to contact TuckerAllen, find out more about that. It is well worth it. For me, as an example, 20 years plus years ago when I did my trust planning, I just sat it on a shelf. And obviously by the time I had it redone by TuckerAllen, that was so far out of date. And it makes sense for me to have an annual conversation and say, hey, how are things doing? What's changed? We have new administration at the White House. Things may change. We want to make sure that your documents are up to date so that whatever you plan will go accordingly. So check that out. Before we move on to Teresa, talk about the next topic, obviously, submit your questions in the Q&A section. We're going to get to those very shortly here. So do that now. We'll get you some answers. Otherwise, check us out on the web. You can schedule a consultation. So Teresa, let's talk about trust administration. Big words. What does that mean? How does it work?
The trust administration happens when you have a trust.
Yeah.
I guess big overview about how we've been talking about how different the money would flow across all these different designations. So first thing, the TOD, POD, direct beneficiary designations. If something doesn't have a beneficiary, it goes into probate. If the beneficiary is the trust, then it goes into trust. And then so now we talk about trust administration. So ideally, you created this trust, you did your homework, and you funded all your different assets. Everything's in that basket, whether it is a beneficiary and it fell into the basket after you passed away, or you put it into the basket while you were still alive. Now that you're gone, your successor trustee is holding this basket for you and has to take care of these assets and distribute it to your different beneficiaries. So that's essentially what the trust administration process is. To break it down a little more, kind of like the first step you have to take in trust administration is essentially take a bird's eye view of all the different assets of the decedent and say, okay, here's asset bank accounts ABC, investment account, retirement accounts A and B, cars ABC. And then you would just go through each one, check for beneficiaries, right? Because that's the first thing we do. And then we say, okay, this one has a beneficiary. All of these have beneficiaries. Who is it? Is it the trust? Okay, then we know that that's going to the trust. And then so then you put that into the trust estate category. And then anything you go through and you're like, oh, wait, okay, Sally A is beneficiary on bank account B. Then you just put that into the direct beneficiary designation category. And then whatever is left, whatever doesn't have a beneficiary on it, that goes into the probate estate category. And then so you're kind of managing these three different things. Your trustee is managing your trust estate, your personal representative is managing your probate estate, and the direct beneficiary designations, I mean, they just can present their death certificate and get whatever direct asset. So now in terms of our work for what we do when clients come in for trust administration, then a lot of times we look at the trust estate and the probate estate. So for the trust estate, Kevin already kind of highlighted the pitfalls of probate because you have to engage with the court. We have to file the original will. The personal representative has to be appointed, take an inventory, and essentially do all the different steps that the court requires you to do. Trust administration is a lot smoother. It's a lot faster. You don't have to work with the courts. You don't have to hire an attorney. A lot of times people still find it helpful to have an attorney kind of hold their hand along the process. But essentially, if you've got a savvy trustee, this trustee can handle a lot of it on their own. So what they would do, your revocable trust, after you pass away, it becomes irrevocable. For a good reason, because you don't want your successor trustee to be able to change the terms of your trust. You put a lot of work into establish your rules. So the trust is irrevocable. Your trustee has to get a separate tax ID for it, so that the trust itself is a separate entity holding these assets. Once you get the tax ID, or the trustee gets a tax ID, the trustee would normally go to the bank that they use, whichever is most convenient for them, and open up a trust account using that tax ID. And then this trust account essentially becomes the consolidator of all the different assets. So you go back to that first list of assets where you created that inventory saying, okay, what are all the different things going to where? And then so you say, what are the different things going to the trust? The trustee then will go to bank account A, present the death certificate to the banker and say, hey, I'm the trustee of this trust, or give me this asset. And then the trustee will put everything in, liquidate and put everything into the trust account. Of course, if you have more specific rules in your trust about like, hey, I don't want my house to be sold for 2 years after I die. I want my house to be kept inside of the trust for the benefit and use of so-and-so, your trustee has to follow those rules. So essentially, the goal of the trustee is to follow your rules, and whatever they can consolidate, liquidate, put it into this trust account. After everything's there, then write checks to all the different beneficiaries according to the percentages that was outlined.
I get it. So there could be, I mean, all these checking account, investment accounts, you're starting to liquidate rather than give them in-kind shares, or, I mean, you want to again work with maybe a certified financial planner to make sure makes the most sense. You know, we talked, there's tax ramifications, maybe people may have heard of like a basis, whatever that may be. So they should be talking about that with an accountant or a CPA or a certified financial planner. But I guess as you suggest, the whole point is to avoid these statutory fees that attorneys are obligated and allowed to get off of your estate if you do it right. Is that right?
Yeah, because your goal is to have everything either have a direct beneficiary or, more ideally, have everything go into the trust estate. In an ideal trust administration, nothing is going into the probate estate because you don't want to deal with that. You don't want to pay the statutory fees. Yeah, and especially if you have a different personal representative from your trustee, then that's two different people working together. It's just a little stickier.
So people watching, they're thinking, okay, now I'm beginning to question whether all my assets are appropriately funded or titled, because we acquire things, we dispose of things over time. Is that something they should think about scheduling a consult with you, with TuckerAllen, to go over and whether or not they should be getting something funded?
Yeah, so if you have a trust, to all the people out there, if you have a trust, make sure everything's funded. And if you created a trust maybe like 5 years ago and you know that maybe you started your homework, you did one or two things, but the remaining things you're not really sure. Like I know retirement accounts are things that people are confused sometimes about how to title it with your trust, or just like other types of assets that might seem a little confusing. Definitely you can meet with us. We can give you advice. And then if we created your trust for you, it's totally your call, but we definitely have some clients that are like, ugh, I don't want to touch that. You do it for me. So we do people's homework for them. So that's also an option. So. And
that legacy protection program, I assume, that's something that somebody thinking, man, that sounds like of interest. They can inquire about that as well, right? And protect them in the future.
Yeah. So the legacy protection program, that you get unlimited calls with us. So you can ask us all the questions after you create your plan. You can say, okay, I'm in the legacy protection program and I just here's the form that my bank gave me to fill out. How do I fill it out? We can provide that advice. We can even tend to say, here's exactly what your trust name is. This is what you would put in for the social security number of the trust. And we'll give all that advice. And under the program, we actually offer to do 2 funding forms for you every year. So
good. Yeah, and that should be enough as you go along and dispose of things and acquire it. So as I mentioned, it's something to think about and ask about. I think it's important. So thanks. Let's get to our questions that we have that come in. Again, if you're out there and you have a question, submit that in the Q&A section. Love to hear from you and we'll get you some answers hopefully. And so let's go right off the bat and let's in the last portion of our virtual town hall today. So Teresa, David says, how do you get my spouse on board with finishing funding of our trust that we had drawn up in 2019? So interesting question. How do you get your spouse to kind of take that next step?
Yeah, so I guess that is an interesting question because you have a couple. One of them is like, hey, I want to get this done. And then the other one is just kind of dragging their feet, thinking, they got other things to focus on in life. I mean, my advice would be sometimes people drag their feet along because maybe they just don't understand how simple it can be to fund your trust. And also maybe the uncertainty or the unknown of it itself is kind of off-putting. So I would say you can reach out to us, schedule a consultation. We can go through all your different assets and I can tell you exactly what you need to do to fund each of those assets. And hopefully that will assuage some of those fears or hesitations in getting it done.
I think it is. I think it's, overwhelming information. It's too much. They don't want to think about it, or they think, what, we've already done the trust. We're good. I mean, that really, I think, is a misconception of, the way that I hear people speak in companies. You just got to do this. Just sign the document, print it offline and sign it and you're done. And you can just rest at ease. And that's just not true. And so, especially with David, I mean, I think David, you said, hey, hon, let's come in, let's talk to the attorney and see why this is so critical. And maybe we don't need it, but I think a consultation will answer that question. So, all right, Kevin, Susan asks, can 2 children both have power of attorney? My children would not appreciate the other being the only one in charge.
Sure. So 2 you can have two, you can have co-agents for a power of attorney like this. And then whenever you do have co-agents for a power of attorney, there's two different ways that you can do that. You can have it set up to where these agents, the co-agents, are acting independently, which means they can each make decisions for the principal. And the principal is just the name for the person who's creating this power of attorney and giving their agents the power. So the principal will be the person that creates it. So it can be set up to where the agents can work independently or they are forced to work jointly. So there's just a few issues though, kind of to highlight with having co-agents on a power of attorney. One of which is that maybe your children are not going to agree with each other on which are the best ways to proceed. And if they continue to disagree and they can't come to some sort of compromise and figure out how to move forward, then the court is going to have to get involved. So that's just something to be aware of. Another thing to be aware of is that, you know, a lot of times with a durable power of attorney, we're talking about your financial power of attorney here, that bank might not want to see co-agents. And even though your document might say, hey, my co-agents, they can work independently of each other, the bank might say, yeah, well, your document's great, but we have our own, you know, like standard operating procedures here. And the way that we do things is whenever there are co-agents, both of them have to be here to sign this document to move these assets. And it's pretty easy to see how this can like cause an issue, right? If one of your children lives 20 minutes from you and the bank that you guys both use is in between you, that person can show up very easily and get their name, you know, signed down as a POA. Your other child might live 2 states away, and now the bank's saying they better be here too. That just can create a lot of issues. So I know at TuckerAllen here, we always try to push. We understand that there can be some, you know, some family tension with only naming one child, but we do try to push for, let's just have a single agent. And if we want to try to make things fair and your mind towards your children, then maybe the durable power of attorney, that will be one child, and then your healthcare power of attorney, let's make them the other child.
Yeah, I think that's right. I mean, I know I've talked about it where I have 5 kids and we wanted each of them, especially the ones that were of age right now, and to have a role. And we actually had a conversation with them and said, are you okay? Look, here's what we're going to do. You know, our daughter is a nurse. She should make healthcare, and you're financially minded and you should do finances. And then this person will be, you know, the PR or the executive or whatever it is, or, you know, and they were all good with it. And they all felt empowered that they had a role and that was their role. And I think that's important to just have that discussion, obviously. And so I think you're right. So thanks. So Teresa, Lynn asks this, how should IRAs, both Roth and regular, be filled out in case of death for beneficiary to not be penalized?
Okay, so I'm going to interpret that question as, okay, if you have a trust, like how should you set things up for your different retirement accounts? Just because I know this is a very common question we get across from our clients when they do their funding homework. So with all retirement accounts, our recommendation is if you have a spouse, definitely have that first person be that primary beneficiary on your retirement account, just because you have the spousal rollover tax advantages so that the spouse will not be taxed on when they receive the IRA or the Roth. And then we say we would recommend the secondary beneficiary to be the trust. And then within the trust, how your trustee can manage any retirement account proceeds is they can make a decision for each beneficiary about how they should hold things in the trust, whether the trust should just be a conduit saying, hey, every year, whatever I get from the retirement account will be passed on to the beneficiaries. Or if a beneficiary is going through a really rough patch and it's probably not the best idea for them, like if they're going through a divorce or something, you don't want to give them all this money right now, then you can say, okay, let me hold it in this trust for you. And then once you're done with that, then I can give you whatever we accumulated. So in terms of titling, spouse first, if you have a spouse, and then trust second.
Okay. Kevin, let's see. Judy asked this. I have assets that I've set up with either a POD, TD, or with a beneficiary. I do have a will and financial and medical power of attorneys as well. Do I still need to have a trust set as well? And if so, why? I know we talked about the addition wills trust, but let's talk to Judy here and give her some advice here. Or not necessarily advice, some direction.
Sure. So first of all, I'm very happy for Judy. She's taken some great steps and a lot better steps than quite a few people that we see. So that's great. As far as whether she needs a trust in addition to her will, I would need to know quite a bit more about her own, her personal situation. But just as like some broad points here would be that, if you have a lot of assets, like we were talking about earlier, if you own a lot of individual stocks, or if you have multiple children, things like that, then I would suggest minor children again. Then I would suggest, let's start thinking about a trust. If Judy is unmarried and she has one child and that child, is 35 and is good with money, and then that will and what she has done so far would be sufficient. But, there's also sometimes people, they have wishes that you can't get into, you can't get through those wishes with a will. Like, let's say they have a child who's not as great as money, or we're talking about some pretty significant assets. They don't want to give somebody, $1.5 million in assets just all in one swoop. So with a trust, you could set it up to where you can have periodic distributions. So it's just, again, it's at this point for Judy, I would need to know a lot more about her situation, but those are kind of some times when people would start to think about a trust instead of just a will.
Great. All right, Teresa. Mary wants to know that Mary's husband recently died. Mary was a teacher and gets a small pension. How will this affect my qualifying for Social Security survivors insurance?
So with this question, I guess I'll take it in two parts. So I'm assuming Mary is getting her husband's Social Security survivors insurance based on his work credits, his work history. And then now she has her teacher's pension. It really depends, because on her teacher's pension, normally they get this pension because they did not, like, teachers a lot of times don't have to pay the Social Security tax, and that's why they get this pension. And then so when you do receive this pension, that does normally mean an offset in the Social Security benefits that you receive too. This is called the government pension offset. So if your teacher job was one where you weren't paying into Social Security tax during the time that you were working there and you received this pension, how it might reduce your Social Security benefits is whatever your pension amount is, take 2/3 of that, and then that's the amount that your Social Security will be reduced by. And then you'll still get your pension. It's just that your survivor's benefit will be less, and then it's just offset by that difference in the pension. So.
All right. Let's see. I think looking through some of the questions here. Kevin B asks, what's a preferred way to make beneficiary and other changes to your trust, such as when a listed beneficiary needs to be removed?
Sure. So for those smaller changes, like just changing a beneficiary, my suggestion would be just to do a trust amendment. And what that is, there's a portion of your trust that allows the trust to be amended, and then the amendment cites to the portion of the trust that saying we can amend this trust. And then what you would do is you would go down to the portion that says this beneficiary is getting X percentage of the estate. And then you would just say under the section of the trust that allows us to amend this trust, we are hereby taking out this beneficiary. And then you would set up your new distribution after that. So that would be a good way to make changes, is through amendments. If it's more than just a few simple changes like that, then you would want to start thinking about a trust restatement, which is basically a brand new trust.
Yeah, good. All right, let's see. Teresa, I know you talked about IRAs earlier. Another question is, what happens to my IRAs after I die? And this comes from Lynn.
So I guess hopefully you have a beneficiary in our IRA. Most people do. So if you have a beneficiary on your IRA, then that beneficiary takes, and if your trust is the beneficiary, I already kind of talked about this, your trustee has that discretion in terms of how to hold or manage those proceeds for each beneficiary. Hopefully you have two levels of beneficiaries, like a primary and a secondary.
Yep. Good. All right. Getting down to a few more here. Kevin, Carol wants to know, what's the appropriate payment for an estate's trustee? Is it flat or a percentage?
Sure. So that kind of depends, I think, on whether we're talking about a corporate trustee or just a regular trustee. Corporate trustees, they're going to take a percentage of the trust assets. So whenever I say corporate trustee, I'm talking about like a trust company, and it's going to be anywhere from 1% to 2% is what they'll take. Whereas just somebody that you've named as a trustee, I think that is up to you. Your trust document is, you can put that into your trust document and say this person should get $5,000 a year for their work as a trustee, or you can say they should get 0.25% of the trust assets for their work. Here in the state of Missouri, we do have a statute that guides us. I won't list it off because it's about 4 letters and 8 numbers and it's all jumbled together, but all that it's saying is just that the compensation that the trustee is entitled to is the reasonable compensation for the work that they put forward, which is pretty ambiguous.
Yeah, right. Exactly. But they should ask for a comp, and obviously that's something reasonable is always left to the objective or subjective standard. So, all right, last question. If you have questions as we're going to this last question that was submitted, do that now. Q&A section, and we'll get to it with the few minutes that we have left. Teresa, question is, both of my parents are now deceased. Both of their names are on the deed, and I am the only child. I lived with my mom until she died. She did not leave a will or any legal notarized document stating her wishes. What do they do?
So I guess for the deed question on the house, let's tackle that first. If both of their titles were on deed and both owners are now deceased, you can see whether they ever did a beneficiary deed. You can go to the recorder's office and then just see if there was a beneficiary listed. If you are the only child and you're the beneficiary, then hopefully they set that up and you can just get the home pretty swiftly that way. If not, then unfortunately, well, like I said earlier, you have to check for beneficiaries on everything. Maybe miraculously, since you're the only child, it's pretty simple, straightforward for them, so you're the beneficiary on everything. Then it'll save you a lot of time and effort. If they didn't have beneficiary designations, like the TOD, PODs we were talking about, and they don't have a will and no trust or anything, then unfortunately those assets would have to go through probate before you can actually receive them. So you can petition to be appointed as a personal representative to open that probate account. Since you're the or probate estate, since you're the only child, it should be pretty easy to get you appointed because wouldn't be that many competing interests for people that would kind of argue that you shouldn't be. But it's just unfortunate if you have to go through the court system, but it's okay. A lot of people do. We can help you too. So
get with a lawyer, walk through the steps. There are things I know like small estates, but obviously with a house, it's probably not, but it depends. I mean, I've had friends who just certain items that didn't reach a certain value. So it was a much faster process, much more affordable. So get a consultation as quickly as you can and get some really good sound advice. So Teresa, Kevin, thanks for joining again to our virtual town hall today, as usual.
Thank you.
So tomorrow, 1:00 Central Time, tune in to TuckerAllen Live on Facebook. Just take one topic. We're going to address that for a very short period of time. Again, you can ask questions there. If you had a question and you thought, Mo, I didn't want to ask it or I forgot to ask it, we ran out of time, tune in to tomorrow, 1:00 Central, 15 minutes. Check out our social media, check out TuckerAllen.com, and look for the next virtual town hall coming up in March. Until next time, have a great week.